have a case out of the 3rd District of Florida that deals with an interesting concept that I want to talk about. It deals with the dangerous instrumentality doctrine. This case is Arthur Sager v. Madalena Blanco and Ricardo F. Blanco out of the 3rd District Court of Appeal. This case, as I said, deals with the dangerous instrumentality doctrine, which is a big word for a doctrine that addresses when a party or a person allows someone else to borrow their vehicle. The law has deemed vehicles dangerous instrumentalities, naturally, because by their very operation, there's a certain amount of danger that's associated with them. We know that by the number of accidents that occur each year. And so the law will actually hold the owner of a vehicle who entrusts another person with their vehicle vicariously liable, which means liable for the negligence or the bad driving of the person that they entrusted their vehicle with. And so in this case, the person who was injured was actually an officer on the scene of a domestic dispute. After the officer showed up, the gentleman who had assaulted his girlfriend drove off with his mother's vehicle. His mother was the person being sued, who had entrusted him with the vehicle. He drove off and through a series of events ended up reversing over the officer on the scene. Officer brought an action, and there were several issues at play, but I want to talk about this dangerous instrumentality doctrine. One of the exceptions to this rule is if a person participates in intentional or reckless conduct that is not foreseeable. So what the law says is if you entrust someone with your vehicle, but they then intentionally harm someone. So imagine, for example, if you entrusted someone with your vehicle, they then promptly drove down the street to run down their girlfriend. Well, in that case, their intentional conduct takes you outside of this dangerous instrumentality doctrine to protect the person who entrusted the vehicle from being held liable for intentional conduct. One interesting facet of this case was that the gentleman who had assaulted his girlfriend was actually charged in running over the officer and was found to have committed a crime in weaponizing his vehicle, essentially. And so as a result, the mother who was being sued stated that, well, because it was intentional conduct, that the officer could not bring an action under this dangerous instrumentality doctrine because it was intentional. But what the court ruled was intentional conduct is not going to be a strict bar to this doctrine. But if it's intentional or reckless conduct that is foreseeable, then the person who entrusts the vehicle still may be held liable. If the intentional conduct is unforeseeable, then the person entrusting them with the vehicle would not be held liable. So it comes down to whether it's foreseeable or expected that this may occur. And so this exception to the rule may come into play. And so what the trial court did is made a blanket exception and said because he was convicted of a crime of intentional misconduct, then this person could not be held liable under this doctrine. But the appeals court actually reversed that decision and said, you're going to have to do a deeper analysis here to determine whether the conduct was foreseeable. There were several other issues at play in the case, but that's the main thing. Give you something to think about the next time someone asks to borrow your car. You do want to be careful about that. Obviously, we don't want to just not let anyone borrow our vehicles, but we do want to be careful and understand our potential liabilities as a result.